If you are a green card holder right now, I need you to listen like your future depends on it, because this could directly affect your legal status, your ability to travel, your path to citizenship, and the quiet sense of safety you've built in this country. Today, a new law passed headline is detonating across social media, and I'm watching people spiral in real time, spouses grabbing passports, parents whispering about what happens if they can't come back, friends texting delete everything and don't travel. And the most dangerous part is not the headline itself. It's what panic makes good people do when they feel targeted. Here's the practical meaning of pass today, and I'm going to be painfully direct. Most of what you're seeing described as a new law is usually a bill that advanced, often in one chamber, and that is not the same as a finished, enforceable law that can revoke your green card overnight. What changed today is not that your status automatically vanished at noon. What changed today is momentum, and momentum changes behavior. Politicians posture, agencies prepare, officers scrutinize harder, timelines tighten, and the margin for error shrinks. And that's why March 2026 is being framed as the line in the sand. So let me calm the fire without putting you to sleep. In the US, for something to become a real law that can be enforced against you, it generally has to pass the House and the Senate in the same form, and then it goes to the president for signature. If the House passes version A and the Senate passes version B, that's not law. That's a fight, a negotiation, another round of votes, and sometimes a quiet burial. And even after a signature, many changes don't slam into your life instantly. They roll out through effective dates, agency guidance, forms, procedures, budgets, and sometimes court challenges, which is exactly why headlines can feel like a gunshot when the reality is a long fuse. But here's where it gets serious, because I will not let you walk away thinking, oh, so I can ignore this. Whether or not the exact headline is overstated, the enforcement environment absolutely can tighten before any single statute changes. And agencies publicly publish timelines and effective dates for rules and procedures that land in early 2026, which is why people keep circling March 2026 like it's a cliff edge. Because in government time, March is not far, March is already being planned. You can see how official immigration systems operate on monthly cycles and future-facing planning just by looking at how the government publishes things like the visa bulletin and filing guidance that's explicitly labeled for March 2026, meaning the machinery is always moving months and years ahead of where the public's attention is focused source. Now this is the part nobody is talking about clearly because it's not as clickable as they're taking your green card. What actually impacts most lawful permanent residents is not a dramatic new rule that hits everyone equally. It's heightened scrutiny on the pressure points, travel patterns, residence consistency, tax and address compliance, old arrests that people assume don't matter, and contradictions that don't show up until you apply for something and an officer has a reason to look deeper. And when fear is high, people make the exact moves that create risk. They take a long trip to wait things out. They delay renewing because they don't want attention. They file a rushed N-400 with mistakes because they think citizenship is a shield they can grab overnight. Or they listen to viral advice telling them to avoid the system. When the truth is, the system punishes avoidance more than it punishes caution. Here's where it gets serious. Travel. If you leave the United States for a long time, you don't just risk inconvenience, you risk questions about whether you abandoned residence, and those questions can show up at the airport when you are exhausted, nervous, and standing under fluorescent lights with your whole life in 2 suitcases. I want you to picture this scenario because it happens. A green card holder visits family abroad and stays just a little longer, then a little longer becomes 8 months, 10 months, a year, and they tell themselves, I'll explain it. But when they land back in the US, they're pulled aside, asked where they live, where they work, why they were gone, whether they filed taxes, whether they still have a home here, and suddenly their answers don't match what's in databases, because databases don't care about your intentions, they care about patterns. And if you think, well, I'll just be honest, yes, be honest, but understand this. Honesty without preparation can still end in a bad outcome if you can't document your ties, your reason, your continued residence, and your tax compliance. Another scenario, address compliance. People move. Life happens. You switch apartments, you switch states, you're chasing work, you're taking care of relatives, and you forget to update your address. And it feels harmless until the day USCIS sends a notice you never receive, biometrics, an interview, a request for evidence. And the system marks you as someone who didn't respond, someone who didn't show up, someone who doesn't follow instructions. And in a tightening environment, I didn't get it becomes a thin excuse if your file shows you didn't update. Another scenario, taxes. I'm going to say this slowly because I need it to land. Your tax history is not just finances, it's credibility. If you are a lawful permanent resident and your tax filings suggest you don't really reside in the US, or you filed in a way that contradicts your immigration story, You can trigger delays, extra questions, and serious scrutiny later, especially if you apply for naturalization. Because N-400 is not just a form, it's an invitation for the government to review your life in a way you may not be emotionally prepared for. Here's where it gets serious for N-400 applicants. People think citizenship is just the next step, but the N-400 process can expose inconsistencies you forgot existed. Long absences, old addresses, selective service confusion for some, prior citations or arrests that were dismissed but never properly documented, and yes, the biggest one, a timeline that doesn't add up. And when officers are under pressure to be thorough can feel like aggressive, even when it's technically just questions, because the stakes are your future. Now this is the part nobody is talking about. Even if you did nothing wrong, increased scrutiny can still mean increased delays, more interviews, more paperwork, more time stuck in limbo. And when you're in limbo, life gets harder. Jobs want documents, travel becomes complicated, family emergencies become stressful, and people crack under that pressure and make one disastrous choice, like signing something at the border they don't understand or withdrawing an application out of fear when they should have sought counsel. Conditional green card holders, if you're on a 2-year card, listen to me carefully. Your life is already governed by deadlines and evidence, and if you file late, file sloppy, or can't prove what you need to prove, you're not just dealing with a delay, you're dealing with the possibility of denial and referral to removal proceedings. That's not fear-mongering, that's the structure of the process, and in a stricter climate, weak evidence that might have slid before can become a hard stop. Travel while something is pending is another silent trap. Maybe you renewed a card, maybe you filed to remove conditions, maybe you filed N-400, maybe you have a re-entry permit question. Travel can be fine, or it can become the moment everything gets complicated, depending on your exact facts and documents. And the people who get burned are not bad people. They're normal people who assumed, guessed, or trusted a confident stranger online. So where does March 2026 come in, and why am I not letting you dismiss it? March 2026 matters less as a magical doomsday date and more as a real-world policy horizon. Agencies set effective dates, budgets shift, procedures harden, and training and implementation ramps up before the public ever feels it. You can literally see the government publish rules and pages that reference effective dates in 2026, which is a reminder that the system is not waiting for you to feel ready source. And there are also formal reminders out there that lawful permanent residents are required to carry evidence of registration, meaning your status comes with compliance expectations, and in a climate of heightened enforcement, those expectations get emphasized and enforced more visibly. Source. So here's the responsible urgency. March 2026 is your deadline to become boring to the system, in the best way. Not invisible, not hiding, not avoiding, but clean, consistent, documented, prepared. Because waiting is dangerous in a very specific way. It doesn't just waste time, it removes options. When you wait, you lose the chance to correct mistakes calmly. You lose the chance to gather documents while they're easy to find. You lose the chance to plan travel intelligently. You lose the chance to talk to a qualified attorney before you're forced to answer questions under pressure. Here's what you do starting tonight, and I want you to hear the tone behind this. Not panic, action. Pull your green card and check the expiration date with your own eyes, not your memory, because memory lies when stress is high. Review your travel history, every trip, especially anything long, and be honest with yourself about how it looks on paper. If you have long absences, start preparing the story and the proof now, not later when someone else controls the conversation. Make sure your address history is correct and updated, and stop assuming mail will find you. Get your tax situation straight. If you filed inconsistently, fix it the right way with professional help, because the worst thing you can do is let a contradiction sit there like a landmine until the day you apply for naturalization or re-enter after travel. If you're thinking about N-400, don't rush a sloppy application because you're scared, but don't drift either. Sit down, look at your eligibility, look at your absences, look at any past issues, and if there's anything complicated, talk to a qualified immigration attorney before you file, because the cheapest advice is the advice you get before you make the mistake, not after. And above all, stop feeding your nervous system with viral misinformation. You are not getting safer by scrolling. You are getting more reactive, and reactive people make expensive immigration decisions. Preparation now prevents crisis later. That's the truth the internet won't give you because it doesn't spike adrenaline, but I will. Your green card is a powerful status, but it is not automatic protection from scrutiny. And the closer we get to March 2026, the more you want to be the person who's already organized, already compliant, already ready. Because when the next headline hits, and it will, you don't want to be making decisions from fear. You want to be making decisions from strength. March 2026 is closer than you think, and the biggest regret I see is always the same sentence. I thought I had more time. This content is for informational and educational purposes only and does not constitute legal advice. Immigration laws change frequently, and individual cases vary. Always consult a qualified immigration attorney regarding your specific situation.